one of the proud promises of the civilized world has always been law, order, peace, and discipline, have long formed the basis on which countries were classified as first world or third world.
People in the West are a little bit tired from the decades of peace, democracy, wealth, and freedom. It is for themselves a little bit boring.
Administrative justice in Ukraine is a sphere in which the resilience of the rule of law is tested on a daily basis.
The Supreme Court of Sri Lanka found the former executive of this country liable for breach of constitutional duties. Rule of law has been advanced in its full plenitude in Sri Lanka.
Even the highest office be subjected to constitutional scrutiny.
We are judges, we are not political actors, and our duty is to protect the rights and the law under the Constitution.
Across Europe and indeed globally, narratives questioning the legitimacy of courts have intensified. The chilling effect of this type of action against the judges is a red line not to be crossed.
In Hungary, judges are not allowed to express political views.
Why is defiance of the rule of law gaining political appeal across the world?
Rest assured that the judiciary holds the final move.
We can uphold the rule of law only to a limited extent by our judgments and opinions, but we do not have means to enforce them.
Politicians must not interfere with the substance of judicial decision, but the organization and financing of the courts is a democratic issue too.
For one, never ever give up.
We simply need an openness to listen.
Thanks to Global South Network, which allow us to believe in a better world of the rule of law.
It's a wonderful initiative.
The Global South Network opened new horizons for judicial cooperations.
Global South Network provide a platform for meaningful dialogue and cooperation, fostering efforts to build a more equitable and resilient legal landscape.
GSN Network continues to expand areas of activity, further strengthening its impact and reach.
The universal concept of justice compels us to join our efforts, and this is the forum for promoting the same goal.
Well deserved for the hectic activity you have made. I am astonished, I am amazed, I was impressed.
May I at the outset commend you, Dr. Reayat, for the immense work that you're doing in the GSN. And the Global South Network is a much admired initiative.
It's commendable. South Network focuses on all disciplines and regions, creating a bridge between academia, civil society, legal community, etc.
Last but not the least, allow me to invite the Right Honourable Datuk Seri Utama 1, Ahmad Farid bin 1, Salleh, Chief Justice of Malaysia, to deliver their response.
Assalamualaikum. The Right Honourable Chief Justices, the Honourable Justices, distinguished guests, ladies and gentlemen. A very good evening. Please allow me to express my sincere thanks to the organizer for the kind invitation to share briefly the Malaysian court's perspective on the rule of law a principle that lies at the heart of every just society. As the saying goes, Rome was not built in a day. In much the same way, the backsliding of the rule of law rarely happens overnight. More often, it unfolds gradually, one small step at a time, through changes that accumulate quietly over the years. Sometimes it begins with the gradual weakening of the checks and balances that are meant to exist between the three branches of government. At first, such changes may seem minor, but as we all know, even small shifts, if left unattended, can slowly alter the course of things. We must also remember that the rule of law is not merely about following procedures. Substance matters just as much. Every legal power conferred by Parliament carries with it legal limits. It is impossible to reconcile unfettered discretion with the rule of law simply because the power was created through proper legislative procedure. When discretion is left without sufficient restraint, uncertainty may quietly find its way in. Public confidence in the legal system may begin to waver. In Malaysia, the federal constitution remains our strongest safeguard against any backsliding of the rule of law. The written federal constitution stands as the supreme law of the land, binding the legislature, the executive, and the judiciary alike. Unlike systems founded on parliamentary supremacy, the supremacy of our constitution empowers the courts to strike down laws that are inconsistent with the constitution. This does not mean that the judiciary stands above the legislature or the executive. Rather, it reflects the judiciary's constitutional responsibility to ensure that each branch of government exercises its powers within the boundaries set by the Constitution. The judiciary is not supreme either. If the government disagrees with the court rulings that declare its actions unlawful or unconstitutional, it is not without recourse. The government can leverage its parliamentary majority to amend the relevant laws or the Constitution itself, effectively overturning the judiciary's findings. In my view, the rule of law, constitutional supremacy, and the separation of powers are closely intertwined. The doctrine of separation of powers ensures that the judiciary remains independent, able to carry out its constitutional duty without fear or favor, and guided only by the law. Over time, through judicial interpretation, our courts have recognized that the rule of law forms part of the meaning of the word law itself, particularly under Article 5.1 of the Constitution. Article 5.1 provides that no person shall be deprived of his life or personal liberty save in accordance with law. But what does the word law mean in this context? Our courts have made it clear that law does not refer merely to written legislation. It also incorporates the deeper principles that underpin the rule of law. From the Malaysian perspective, the Federal Court has observed that a central element of the rule of law is the equal subjection of all persons to the ordinary law. And this is not absolute, as the King enjoys personal immunity under Articles 32 and 183 of the Federal Constitution. Yet, the King's powers remain constitutionally constrained, meaning the rule of law is not displaced, merely qualified. Just as importantly, the law must be capable of guiding conduct. It should be clear, reasonably stable, and applied equally to all. In other words, while Parliament may enact or amend laws, this power is not unfettered. Fundamental liberties guaranteed by the Constitution cannot be undermined lightly, and certain provisions, particularly those relating to the position of the Malay rulers, are afforded even greater protection against legislative interference. In short, the safeguards are very much in place. For a law to satisfy the requirements of the rule of law, certain basic characteristics must be present, though non-exhaustive. A. The law should be clear. B. It should be sufficiently stable. C. It should be of general application. D. It should generally operate prospectively. E. It must be administered by an independent judiciary. And F. It must respect the principles of natural justice and the right to a fair trial. The rule of law must not remain an abstract idea. It must find expression in real decisions and real cases. In Malaysia, the doctrine of proportionality serves as a key judicial tool in safeguarding constitutional rights under Article 8(1) of the Constitution, which guarantees equality before the law. This constitutional guarantee mirrors A.V. Dicey's conception of the rule of law. Whenever Parliament limits a fundamental right, the doctrine of proportionality is immediately engaged, requiring the state action to meet a three-stage test of sufficient objective, rational nexus, and proportionality, ensuring that the constitutional rights are not curtailed lightly. Dicey gave us the rule of law as a rigid structure, mainly premised on the absence of arbitrary power and equality before the law. But in the modern Malaysia, with the rapid rise of AI, complex administrative bodies, and global digital governance, the challenge to us is even greater. Our job today is not just to defend the rule of law, as Dicey wrote it, but to ensure that the law doesn't just rule, it must also serve. Distinguished guests, ladies and gentlemen, so how to arrest the backslide when you sense it coming? For one, never ever give up, as we are in a losing game of chess. Rest assured that the judiciary holds the final move. We do not seek to win a political match or recognition, but we are here to ensure that no player, no matter how powerful, knocks over the board. That is how backsliding can be checkmated. In upholding the rule of law, the courts ensure that legislative and executive powers remain within their lawful limits. At times, this may create the impression that the judiciary stands above the other branches of government, but that is not the case. The powers of the courts are themselves subject to limits. Our constitutional system ultimately rests upon a framework of checks and balances, where each branch of government plays its proper role. I remain confident that the Malaysian judiciary will continue to stay the course in upholding the rule of law and ensuring that it remains a guiding principle of justice in our country. Only by this way can a potential backsliding be avoided. Thank you for having me.
Thank you very much, the Honourable Chief Justice of Malaysia, for delivering his response.